Hello, fellow Toolboxers. Welcome to episode 298 of the Immigration Lawyers Toolbox. As always, we're having a lot of fun doing this. So much info coming out and so much different pieces of content we're trying to put out. This one is with a delay. My regular monthly interview with Gregg, the fantastic immigration lawyer, partner at the Courageman Law Firm in Florida, but also the host of Immigration Review, a very popular immigration podcast. Very happy to support his podcast with all the good in-depth content he's providing. So we regularly talk every month about some top cases. We're going to get to that in a moment. The immigration field is bound with so much more content. So many people are getting more and more videos and podcasts out. Good to listen to all of them to get the best information, although we're probably number one. Having said that, I do want to thank our special sponsor for this episode, Serenade. You already know them, but technology company that's been a transformative leader in the immigration space for nearly 30 years. E-Immigration, the product that you know, by Serenade, is a modern practice management software for immigration-focused legal professionals to manage your cases, clients, forms, billing, and much more, all in one solution with an intuitive interface and bank-grade security. The software is trusted by tens of thousands of happy attorneys and their paralegals and team who use it to save hours of time for both themselves and their clients. They have the highest ratings for immigration software on the popular review site Capterra. They have the highest rating, so for most likely to recommend, be it best support, best ease of use, best value, and a handful of other awards. Worth mentioning one last thing, what really separates the immigration from the pack is it's comprehensive across over 100 fields. Comprehensiveness. These include features you might not use today, but you can save time tomorrow, like e-filing. E-Immigration is the only platform that offers e-filing for all USCIS forms. Stop paying for multiple software. Let E-Immigration handle all your practice needs. Get more information and schedule a private demo today by visiting Serenade's website or calling 1-800-617-420. It seems like I'm missing a number right there, or emailing sales@serenade.com. Email is always the best. Sales@serenade.com. That's Serenade with the C. I'll figure out where I'm missing on the phone number right there. But having said that, we have all our own stuff we're doing. We're trying to create a bunch of programs. There's a lot of work to do. If you're listening to this, you want to get involved in the toolbox in one way or another, education-wise, supporting yourself, making better practice, better market, all that kind of stuff. Best thing to do is just email us. So have your email. Add you to a newsletter. It says new things come along that you can join. Groups, events, free CLEs, which we're going to do more and more of, training, all that kind of stuff. You could hear about us. Just email me at info@immigrationlawyerstoolbox.com. And hey, wherever you're watching this, just leave a 5-star review. Having said all that, none of this is intended for individual legal advice. Please consult with an immigration attorney on your own. This podcast is intended for immigration practitioners, not for individuals. And with that, let's get it started. Hey, Kevin, good to see you.
Hello, John. Happy August. So
Thanks.
For the July cases.
Yeah. Do they call it the dog days of August or dog days of summer? What is that dog days thing they say?
I'm a big fan of dogs, to be honest with you. Like, I wouldn't mind if everything's the dog days, but I would think that if there had to be dog days in summer, we're probably smack dab in the middle of it. It is hot. It is hot in California, as you and I both know.
Yeah. And I mean, for everyone listening to this, I saw a map that whole America essentially is on a heat wave right now.
Yeah, we can't really complain. And you should know, though, I'm pretty amped up before, it's getting towards the end of the day in California. And I started early. Needed to get a BIA brief uploaded. Thank God for e-filing.
Mm-hmm.
But before this, I was listening to Bombs Over Baghdad by Outkast, and it's impossible not to be amped up after that song. I think it still remains top 10 hip hop song of all time, and the video is outrageous. I don't know when the last time you saw that was, but it's
the video in 15 years probably, but the song definitely comes up.
Like the song doesn't even. It's immediate. Like, it just smacks you in the face. It's good stuff.
But that's a good point you make about getting hyped up, or a dumb point, but getting hyped up about music. It's good to have, and it's something I got to do, but have like a playlist of songs they could play just to, it's like a drug, hitting a drug that's not going to be, problematic. So it's like it pumps you up before you do something, gets you in the right mindset. I went to this conference with a guy. He's like, you always got to do fun music at the beginning to get the conference pumped up and stuff like that, so you come in strong, so it's not boring. So it has a big effect on your day and all that kind of stuff. So it's a good thing to do. I have a bad habit now of, like, I watch a lot of educational videos on YouTube, and I keep saying put on Pandora. I use Pandora on Spotify, and like play music, because like you have to have attachment with music for a lot of people to just keep life smooth. So it's really important.
Sounds good. I like the idea of doing it before a conference panel. I might incorporate that and see if we can do that. That sounds fun. I wish that I could listen to music while I did work. It would be great. I can't do it. I can't think
Oh,
with the music on. But I
no,
can think
that's just
I can think with the music on before I prepare for your podcast, John,
yeah.
because I've already read all these decisions. So
Well,
no
yeah,
offense to you.
I like the conference idea because it's kind of like boxers when they come out. There's music pumping them. Ayla should do that at conferences when it's starting. Like they probably pay royalties or something like that to these artists, but uh, everyone, the panel people don't come up until like the music plays and they walk
Yeah,
up. It's hyped up. Each
right.
person gets introduced like that instead of
You
just
do it enough
waiting.
times that people get to know what your song is.
Yeah, that's actually a good thing. We should make it that a thing. I mean, it's going to delay getting the conference started by 10 minutes, but it's going to be more fun.
I'm choosing Bombs Over Baghdad.
Well, having said that, let's jump into it. What do you got for us this week or this month?
I promised on your show last month that this month was going to be Fourth Circuit month because you and I did the June cases like mid-July last month. But actually, and this is totally Fourth Circuit month. Fourth Circuit has gone off. The Fourth Circuit is now what people used to say about the Ninth and the Second Circuit. The Fourth Circuit is Asylum Central, pushing that law forward. The Ninth Circuit is at war with itself, and the Second Circuit just isn't publishing as much immigration cases anymore. But before I get into those Fourth Circuit cases, I'm actually going to start with the Third Circuit, because the Third Circuit and the Fourth Circuit issued essentially the same decision this year on deficient notices to appear. That pesky deficient NTA issue that begins with Pereira and Ms. Chavez at the Supreme Court in the in absentia motion to reopen context, which really is the next frontier. Because I can't, I've said it so many times on my podcast, I've even said it on your show too, like, if all of the circuits go the way that these circuits are going, we're talking about tens of thousands of in absentia motions, of in absentia removal orders issued since 1997 that almost surely began with deficient NTAs that didn't have the date, time, or location, one of the three, in that NTA, and that need to be reopened. And I'm not gonna lie, like, as by my count, they need to be reopened in the first, third, fourth, and ninth circuits, and it gets a little complicated in the fifth. The 11th Circuit doesn't really know what's going on. It's issued a published decision that is weird, but then it disagreed with that in an unpublished decision with more, which you can't do. So it's like, what is that line to walk in the 11th? But again, first, third, fourth, and ninth circuits. I mean, that's already tens of thousands of in absentia removal orders since 97. And the third and the third is Madrid Mancia, the Attorney General of the US. The Fourth Circuit also published just the next week in July is Lazo Gavidia v. Garland. And the Third Circuit's is more interesting. They go through the history of all of this, but this is all statutory interpretation, this textualist world that we live in where judges, they only care about the text, and it's the literal meaning, and dictionaries have all this power, and we don't care about legislative intent, apparently, or fairness, or a living constitution, for example. In this textualist world, though, sometimes that can be to the benefit of the non-citizen, because the motion to reopen statute says that a court that an in absentia removal order, that is, they didn't show up to their hearing and they get ordered removed, may be rescinded at any time if the alien demonstrates that the alien did not receive notice in accordance with paragraph 1 and 2 of section 239A. Restated, it gets rescinded if the non-citizen doesn't receive notice in accordance with 239A. And 239A lists what needs to be in a notice to appear, and it has to have the date, time, and location of that first hearing. And indeed, even going in absentia itself must be premised on a finding that the non-citizen received notice in accordance with 239A. That's another statute. So, like, very clearly, the in absentia statutes are tethered to proper notice in accordance with 239A. That's what the First, Third, Fourth, and Ninth Circuits have now all said. By the way, the First Circuit said it by vacating the BIA's contrary decision. So matter of La Para, in my opinion, is not good law anywhere because the First Circuit vacated it. They're all saying this because that is what the statute means. As the as both the Third and the Fourth Circuit, they're saying this, and they don't care whether or not the non-citizen updated his or her address properly. These battlegrounds for in absentia motions to reopen, it used to be, did the non-citizen properly give ICE their address, properly update it? That's still relevant in the Fifth Circuit, which doesn't make sense to me, but it's not relevant to the Third and the Fourth, and seemingly the First and the Ninth. This is all about the in absentia statute. It has nothing to do. And as the Third Circuit says, I mean, I'm just going to keep going on and on with it. This is the quote: "No reasonable diner would expect to get seating for two by calling a restaurant to change a reservation he made." So, like, this is the quote. The third: "Confusion, not a boarding pass, would follow a traveler's request to change a flight from business to first class when no seat of any kind had been purchased." This is the analogy the Third is saying. It doesn't matter if the non-citizen updates their address when they haven't received the required notice in the first place. The Third Circuit's saying it with some very fun language. In dissent, the Fourth Circuit judge who was dissenting in Lazo Gavidia said, and this is not the first judge to say this in dissent, I'll quote, "After the majority's decision, every non-citizen who is removed in absentia after receiving an incomplete NTA can obtain rescission of her removal order, regardless of whether she provided an address at which she could be reached, and regardless of whether she actually received the notice but chose to skip her removal hearing," end quote. This is the judge in the Fourth lamenting this. But the judge isn't wrong. The judge is correct, but this is what the statute requires. I mean, this is tens of thousands of people getting a second shot. And of course, your more stereotypical situation is these people who were ordered removed. They didn't depart. It's been, 15 years. They're married to a U.S. citizen and they can adjust status. Or they can at least get an unlawful presence waiver and consular process, but for this removal order.
So a couple of things. One is, like, you said the judge is supposed to make a determination that proper notice was made in their decision. That's one of the things. So in decisions for judges to, do in essential orders, is that part where they write, like, check the box that notice was given? Is that part of customary that judges will go into?
At every in absentia hearing, there's always going to be this preliminary determination where essentially DHS submits the NTA and the I-213. The judge says notice was proper, removability is established. And in my opinion, an IJ can't do that in the First, Third, Fourth, or Ninth Circuits. The Ninth was pretty explicit in Singh. And so you shouldn't have this issue going forward, because judges in those four circuits, at least, they're probably not going to go in absentia anymore if the NTA is deficient. But of course, this is all very new. Tens of thousands have already happened. And so that's the future. They can't go in absentia in the first place, but redressing what's happened in the past, they got to reopen it. And by the way, in that Third Circuit decision, which why I like it so much, I actually just used it in a brief, again, Madrid-Mencia, the Third Circuit explains how this all came to pass, at least as its reading of the history. It really begins with the Carter administration's INS, with orders to show cause, making the determination that including the date and time and location of the first hearing, the order to show cause was just too burdensome. And that is actually okay, because an order to show cause wasn't tethered to INA 239A, it didn't even exist yet. Order to show cause doesn't require, like an NTA does, post-97, that this information be included. BIA has already issued a decision on that, and in my opinion, they're right, as have some other circuits. But then, after NTAs came into force, after 97, INS and then DHS, they never changed their position. They actually doubled down and said, we can't do this, so we're not going to do this. And to me, that's affirmative misconduct. I mean, that's not negligence. That's not a mistake. That's like, we know what we have to do. This is a Third Circuit, by the way. We know what we have to do. We're just not going to do it. And this is the chicken coming home to roost. And what other applications can, in my opinion, affirmative misconduct by DHS and INS post-97 get to individuals who have been subject to this system?
So my second question is, should lawyers especially in that jurisdiction, do massive amounts of Facebook ads and TV ads right now to deal with these. This is like a boom for business.
I disagree. I think that they should all come to me and I will file the, no, I mean, I absolutely, you gotta, not even more so, I mean, putting that aside, like, you got to kind of look at like all your cases, all your past cases.
Yeah.
What was the NTA like? Should you be contacting old clients? I don't think you have that obligation, but like, that's certainly an issue spot. The moment someone comes into your door, it's as important as any issue, more important, really. That today the BIA issued an amicus invitation that, to me, like, they could use all the fancy language they want in that amicus invitation, but to me, they should have just asked, did we wrongly decide matter of Fernandez last year or this year? I don't even, last year. Like, were we wrong in what we said about deficient NTAs and whether or not, and how it could be remedied? Now, that's separate from the in absentia issue, but I don't understand why they issue this amicus invitation that they issued today if they weren't rethinking matter of Fernandez. Fernandez essentially said DHS can cure a deficient NTA, but as I've been arguing, what does that mean? And actually, the dissent said this in matter of Fernandez. What does that mean? DHS can't file an I-261 as they've been doing, because you can't use an I-261 to amend something that isn't started properly in the first place. The 261 amends a proper notice to appear. But all of these cases are making very clear that an NTA that's deficient is not a proper NTA. So you can't amend it with an I-261. And so if that means that you need to file a new NTA when proceedings are started improperly, well, there can never be two NTAs in a case. So it really requires termination. And then DHS can do whatever they want and file a new NTA. But like, I mean, that's the board today in their amicus. I don't understand how you can create a new form. And a new regulation. I don't know. That's a bit separate, but it's all the same chaos that has been unleashed on us by Pereira and Chavez, but which really is just what the statute was always saying, and what smarter immigration attorneys than me have been arguing pre-Pereira. And in my defense, I wasn't really an immigration attorney for that long before Pereira, so I'm gonna get out of it. I can't speak for everybody else.
Well, all I say is, like, if I was a young, hungry attorney that does remote defense, I'd find the older attorneys on the verge of retirement and say, listen, I'm gonna look over your caseload. Well, split in half, but let me go back and catch all these and contact them.
That's a good point. Give me some money. Let me look at your client files for the last 25 years and start contacting clients. I mean, the floodgates are, it's not even discretionary. And by the way, then you got decisions like matter of Chen from the board, and the circuits have said it too, that say the non-LPR cancellation of removal 10-year clock doesn't stop ticking with a removal order if the NTA was deficient.
Yeah.
I mean, so what does that mean? Like, even for the people who don't have qualifying relatives and who weren't ordered removed in absentia, if you can meet the other burdens for reopening, then you have a valid motion to reopen. If, for example, non-LPR cancellation was denied way back when, because you didn't have the 10 years, based on a determination that the NTA stopped the clock, it didn't, matter of Chen and circuits. I mean, this stuff is everything. I
mean, this is going to Supreme Court. When does Supreme Court announce who has written stuff?
I do think it'll go to Supreme Court. They announced what they grant cert on, I want to say, in the fall and really through early spring. There is a circuit split with that 11th Circuit decision at a minimum. I don't see how this in absentia issue doesn't go to the Supreme Court either next term or the term after.
I would say people need the thing is, as soon as possible to request reopening, because you never know what in the world is going to happen to the Supreme Court. But even if you request reopening, it doesn't, I don't know, immigration court, it's going to take like a year to even get a hearing or get someone, could do that fast.
I don't think so. That's not a hearing. That's a paper. That's the papers. Honestly, DHS has no argument in those 4 circuits, flat out. If it's an in absentia, that's on the papers. I used to work for the immigration courts and would assist.
This is a huge deal. This is like,
it's everything.
I want, like, the immigration lawyer nerds and stuff will get into this, but this should be on the cover of New York Times. This is like a really big deal. This is like,
well, I hope it's not, because I feel like
they politicize like hell.
We don't need to. I'd prefer not to go to the Supreme Court. I'm perfectly happy with these 4 circuits. Includes the 9th, which is where the most removal orders are. I mean, the Fifth Circuit's rule is obnoxious and it doesn't make sense to me. And so maybe it should get resolved, but like, who knows? Like Pereira was 8-1 with Alito and dissent. Ms. Chavez was 6-3.
Know precisely what you're aiming at. If you
Sorry, I'm getting my calculator out. I'm trying to see how much money. So let's say, like, how many cases on this? There's what, like 20,000 people will get hit by this or more. How does it look like?
I don't know how many people have been ordered removed in absentia since
At least
97.
10,000.
I'm sure FAIR has the statistics.
I mean, I'd say 10,000 people. It costs at least 5,000 to deal with their case in some form or fashion. It's $50 million in the pot, but probably more. Both is going to cost more, and there's more people. Wow, this is like $100 million game, probably at least, like in our field all of a sudden.
Yeah, no, it's a lot. More important, it's all this relief for individuals.
Yeah, definitely. You talk about the humanitarian side. I'll talk the business side.
Yeah.
Well,
That's
thanks. This is like groundbreaking. I'm glad you're keeping us posted. I mean, if you watch our shows for the last 3 years, or last how long, it's like this situation is like this slow train wreck. This happens. Like this is happening. How is this going to play out? I don't say a train wreck is good that comes out of it, but
it's everything. It's everything. It's so huge. It's so like Ms. Chavez was 6-3. I want to say the chief, certainly Alito, and I'm not sure who else was in the dissent. So like, what's going to happen this time? I mean, clearly, it's going to be at least 6-3, I would say. And I mean, do you get a win? I'm a little scared because it's already so favorable, but it's inevitable, I think.
Yeah, people doing like the textual analysis that they're doing, especially because of this majority. Like they, I guess, gotta read it the way the majority of circuits are reading it. Because they have been doing that in like the Supreme Court, the way they've been handling things. So it does go pretty consistently towards this being law of the land.
Yeah, I don't understand. I don't see how the Supreme Court could hold otherwise, but of course, that's never.
Yeah, it's like a jury trial. You never know.
The 11th Circuit has already held otherwise. The counter argument is essentially that if you don't provide proper notice, you're not entitled to all these protections, including receiving notice in a court as the in absentia removal order statutes require. Or you could go back to like a two-step process that a notice of hearing cures it, but I do think Ms. Chavez destroys that concept. Yeah. But I mean, that's essentially what the 11th held, and I don't really understand that because this flaw happens at the NTA before notice, before any address considerations even come into play. But, you have at least one circuit who's already essentially held that, so. And then the fifth has like 8 decisions on this, depending on the context. The fifth is out of control. So, reasonable minds can differ in the South.
Interesting times. So, if I wasn't so into USCI stuff and I was being my career, I'd probably go down this route and try to argue these, just make a career, but at least the next 3-4 years, just hustling.
Make me a billboard, put my face on it.
We should start soliciting some business, but it's a tricky concept to get the client for them to understand because you're getting a lot of calls from people who have like no idea what they're talking about. So you have to have a system. But inevitably, this is a big deal, and there's people who have money to do it, so it's worth doing. I'm sure a lot.
It's not even that complicated a motion. You write this motion one time, and then you replace the circuit precedent, and you're done. I mean, I've already written the motion, and that's without all this good precedent.
Maybe I'll hire an associate just to do this and do YouTube and TikTok ads, dance a little bit. Hey, in order. Did you not
do the thing? You point to the corners and like an in absentia order shows up and a motion shows. I don't know.
No NTA, wrong NTA.
I don't know what the kids do these days.
Well, damn, that's an opportunity right there. Well, anything else?
Oh yeah. Now pardon to all your viewers, I've got my fan off here for audio, but it's getting hot in this office. But I'm gonna keep it off for the best audio because
you can't hear it. They could probably hear my kids screaming the next door. That's what's getting me. The fan didn't.
Well, you know what? I'm gonna turn it on then.
Yeah,
so I apologize in advance. But I mean, audio is everything. 2 podcasters. I mean, there's nothing worse. I record my podcast. If a plane goes overhead, I stop.
I pulled my microphone out of the dustbin. I never used it, and I'm like, I was listening the other day. I'm like, oh wow, this sounds so much better. Like I don't have it on right now, but it's like it's so much easier on my listeners' ears. So sorry, I just use a computer for the interviews, but when I do it on my own, it's so much better.
Going to the fourth, then it's the Asylum stuff. First, Ullah v. Garland, Ben Winograd, who is a regular on the podcast. I'm essentially a marketing agency for Ben because he does all these great wins in the Fourth Circuit, particularly. Ullah v. Garland, it's a recent one. Well, they all are, right? July. This is about an individual fears the Pakistani Taliban. And quite frankly, with like everything that happened to him, it is surprising that he didn't win before the IJ or the BIA. I mean, this is like a pro-American helping American armed forces in Pakistan who are fighting in Afghanistan. And if you don't know about the Pakistani Taliban, they are quite the force. They're the entity, for example, that shot that young woman Malala in the back of the head, and she survived, and now she's that thing. That's the Pakistani Taliban.
Yeah. Oh, they're hardcore, yeah.
Quite friendly with their brethren in Afghanistan. And Mr. Ullah had quite the experience there. And the Fourth Circuit was pretty harsh on the BIA for permitting this denial of asylum to go forward. You know, I mean, they could find him anywhere. They found him in Peshawar. Spending a month in hiding in Islamabad is not reasonable relocation. I mean, the Fourth Circuit sent it back for, what did they send it back for? I want to get it right. With instructions to grant his application. The Fourth Circuit sent it back and said, grant this man asylum, which is a hell of a thing. that doesn't happen often. But the reason I love this so much, and again, I've already used it in a brief, is because the IJ found that Mr. Ullah had suffered past persecution in Pakistan, but had held that the record showed that he could reasonably relocate and avoid the Pakistani Taliban. And so that is, that takes away his asylum. In his case, because again, he spent like a month in Islamabad. Anybody who's ever spent a month, actually, I've never spent a month in Islamabad, but I feel like, well, we had a case in Islamabad. I said it we had a case in Islamabad. I said it on the podcast during depositions in a case that we took in Islamabad. Oil and us went to Islamabad. I didn't go. I wish I could have. And while we were in Islamabad, the Trump administration moved the embassy in Israel to Jerusalem.
Yeah. And
protests got so serious in Pakistan that Oil and our attorney weren't allowed to even leave their hotel. That's how dangerous Islamabad was, just because they moved an embassy. So, a little pushback on real world experience that Islamabad is necessarily so safe. But putting that aside, the Fourth Circuit makes clear that to meet the burden to establish that relocation is reasonable, that's DHS's burden once the non-citizen establishes past persecution. DHS's burden is to establish that relocation is reasonable for the rest of the applicant's life. The standard is for the rest of their life. And query how DHS meets burden that literally goes for the rest of an applicant's life. I mean, that's quite the evidence. I don't even know how they could meet that. I would argue that, so there's two ways to rebut a well-founded fear when past persecution has been shown. One is reasonable relocation. The other is a fundamental change in country conditions. I would argue that fundamental change in country conditions also has a for the rest of their life standard in the Fourth. And that is just a hell of a burden.
Yeah.
And that is the burden on DHS in the Fourth. So remember that, and good on you, Ben. Actually, it relies on a prior Fourth Circuit decision. So not to take away from my good friend Ben, but actually that was already the rule in the Fourth Circuit, but it has been re-emphasized in the Ullah v. Garland decision. So quite a case, which then just brings us to Chicas Machado v. Garland, also out of the Fourth. And this is one of those other good cases. It's about fear of gangs in El Salvador, MS-13, your classic case that so often is denied. But in this case, one of the reasons Ms. Chicas Machado won is because very smart counsel was able to tie her fear of the gang, not necessarily to a political opinion or a particular social group, which then gets to be this whole big fight, but to her religion.
Mm-hmm.
Her religion, because she gets targeted by the gang on her way to and from church. She's an evangelical Christian, by all accounts, very religious, and she's getting targeted because the gang thinks, first of all, they don't love, that she's such a religious person, that the gang isn't the most religious of things, but also, more importantly, that as this renowned, local, everyone knows she's a, for lack of a better word, good Christian girl, she could help them with their criminal enterprises and wouldn't be suspected. That's what the testimony showed. And so not only is this great because it's a guidepost for turning a fear of gangs into a religion claim, and of course a religion is a protected ground under the INA. It's one of the 5 protected grounds, and so you don't have to argue about particular social groups and all that madness. But this is a great decision on nexus, and this is not necessarily the law in all the circuits, but this is, nexus. Okay, fine, the gang is targeting you, but are they, and let's even assume it's with a religious component, but are they doing it on account of your religion, or is your religion just tangential? And the quote from the Fourth is this: use as a potential asset to the gang because no one would suspect her given her activity and conduct with the church was inextricably intertwined with her religion, end quote. The gang's threats of death were directed at Miss Chicas Machado and not another person, because she was a practicing Christian and an active member of an evangelical church, which made her useful to the gang, end quote. Asylum law, the nexus analysis does not, quote, depend on the ultimate goal of the persecutor, end quote. That is, unlike how Trump attorneys general and some BIA precedent would have you believe, nexus doesn't require that the persecutor be trying to overcome or have an animus towards that protected trait, in this case, religion. It is sufficient to the Fourth Circuit that the gang was targeting her and not somebody else because of her religious practices. And that, even though they wanted to do it for criminal aims, not because they necessarily hate evangelical Christians. And so that's a hell of a ruling too. And that's why the Fourth Circuit is the Immigration Review podcast's Circuit of the Year. The circuit, the award's been awarded, and it's only August 2023. The Fourth Circuit is really putting immigration law, it's at the tip of the spear right now, in some respondent-friendly precedent.
Now, like in El Salvador, they have this new president who's like cleaning up all the gangs, put them in prison. I wonder what effect that's going to have on the whole gang member arguments for El Salvador eventually.
Well, I think that's a disputed sentence you just said. I'm no expert on it, but I'm not confident that he is doing that, or if instead he's done what Salvadoran presidents have done for the last 20 years, and that is literally pay the gangs money to make them stop killing each other. But once those deals fall through, all hell breaks loose. I truly don't know.
Yeah.
But I'm hearing other things, and I'm hearing that in this sweep of Salvadoran suspected gang members, young men are getting swept up in it and going to jail and being targeted by police, even if they're not affiliated with the gangs. So
that's gotta
again,
suck.
that's why
and then you go to prison with all these gang around you. You're not.
That's right. That's right.
Oh, God, that's terrifying.
I'm not an expert. That's why I hire experts for our cases. I'm not going to sit up here and say I know what's going on in El Salvador. I do think
that could be an asylum thing too. My government is going to put me in prison, accusing me of things I'm not. Maybe that's
100%. Oh yeah, no, there are cases all the time with a imputed particular social group that is gang, believe MS-13 members, but you're not. That is a cognizable ground for asylum as well. Those cases happen for sure in the Fourth Circuit, by the way. So,
a lot of business opportunities, advertising, billboards in El Salvador. Hey, do you have a claim?
I think it was the Ninth Circuit a couple of months ago. I might have talked about it on your show. They did it. They granted a petition for review for an imputed lesbian from El Salvador. She wasn't a lesbian, but her community thought she was and persecuted her because of it. So that is alive and well in the circuits, imputed particular social group.
Interesting. And asylum law is creative, not creative, but just there's so many different angles to everything. It's amazing. Well, good stuff. Any more Fourth Circuit goodies and treats?
No, come on. I've given you. If I gave you any more, people wouldn't listen to my show.
That's true. Well, I think a lot of people listen to your show, Immigration Review. Wherever podcasts are found. You've had some. I saw you doing interviews too. I got to talk with A-list president too. I'm meaning to catch up with them. But they did a good job on doing all sorts of different podcasts and different kinds of things.
Thanks, John. I try not to step on your toes. I only do like 5 interviews a year. It's not much. It's not much.
We'll do a good job. You do a good job. It's not a bad thing to just get more exposure to great immigration lawyers. That's the goal, is just to uplift the practice. So anyway, it's done, I'm happy.
Farshad Awji, by the way, from Iran. I know you're of Iranian descent. That guy's got a story. Aylah's current president, and I'm sure you two could talk about a lot of things that I don't have knowledge of.
I met up with him at the conference. I wasn't there the first day, so I didn't see his speech, unfortunately. And I don't think they recorded that for us to hear.
No, they did. No, they did. If you actually look on his LinkedIn, you can see him and Jeremy's speech. I linked to it on my show notes, actually. He brought an American flag on stage, and he gave everybody a heart attack in Ayla because they didn't know he was going to do it. He just like walked off stage for like 3 minutes. And it was like, did Farshad just leave the conference? But he's got a crazy story, Farshad, as everybody who lived through the revolution in the 70s did.
But like Il National's YouTube is the first thing, 21 minutes, 23. So I'm going to catch that up. I talked with them. I was really happy to hear that. To be honest, I don't follow the politics. So I saw him. I'm like, hey, didn't you win something? He's like, yeah, I just became president. I'm like, oh, yeah. I felt like a dummy right there.
Not a great thing to do at the Ayla conference, right?
But yeah, that was an interesting place. I liked it a lot, actually. I wasn't expecting the hotel to be so nice and just a lot of fun, like it was.
I like that hotel. I don't love going back to Florida under the current administration, although I'm from Florida. But I liked that hotel too.
Yeah, very fun. I didn't leave premise on the Friday night or Saturday night party, but I was just walking around, seeing people. It was a very good experience. And so yeah.
Agreed.
Well, we're good to see you. We'll get this one out in a week or so. But till next month, have a good one, man. Appreciate you coming on again.
You too. See you, John.
Have you ever felt that the road to establishing a successful immigration law firm is riddled with unexpected obstacles and setbacks? I've been there, and I'm here to tell you, you are not alone. Picture this. My wife, then girlfriend, and I had just landed for a vacation, only to be greeted by a voicemail that changed everything. In an instant, once the plane landed, she lost her job. The very one job that was supposed to support us while I launched my own solo immigration law firm. Suddenly, our financial cushion vanished, and I was thrust into the high-stakes world of entrepreneurship with no safety net. Despite a slow start and a discouraging lack of leads and referrals, I remained determined to build a law firm that provided a 5-star client experience. After countless hours spent researching, watching, and implementing marketing strategies with mixed results, I eventually began to see my firm's revenues not only surpass my previous revenue and salary as an associate, but double it. Today, I run a successful law firm with a team of associates and support staff, and I'm the proud founder of the Immigration Lawyers Toolbox magazine, podcasts, courses, workshops, and more. But my journey wasn't easy. I made many mistakes, wasted time and money, and wished I had a mentor to guide me through the challenges. Although I was fortunate enough to find a few peers who offered support, I couldn't shake the feeling that there had to be a better way. That's why I decided to be the change I'd wish I'd seen. This month, I'm thrilled to announce the launch of the Immigration Lawyers Toolbox private mentorship and peer group. This exclusive group is designed to bring solo and small firm practitioners in a monthly, private, and intimate setting to openly discuss business strategies, share successes, even exchange invaluable tactics that they wouldn't share anywhere else. By joining this premium group, you'll not only benefit from my hard-earned expertise, but also forging long-lasting relationships with like-minded professionals who are committed to elevating their practices. Space is limited for this game-changing opportunity. If you're ready to make a real, lasting impact on your business, simply email me at info@immigrationlawyerstoolbox.com. Again, that's info@immigrationlawyerstoolbox.com. And I'll send you all the information you need to get started. Don't miss this chance to transform your immigration law firm and reach new heights of success.